We are now continuing our ceremony to the next agenda, that is to hear the keynote speech, which will be delivered by His Excellency Judge PAIK, Jin-Hyun, former President of the International Tribunal for the Law of the Sea. He's now with us, connected online to make his keynote speech. Judge PAIK, are you here with us?
Yes, I am.
May I ask you to deliver your keynote speech, please?
Okay, thank you. Good morning, President Park Do-kyung, Deputy Minister Ham Sang-wook, distinguished participants, ladies and gentlemen. I'm pleased to deliver a keynote speech in the 5th International Conference on the Law of the Sea, hosted by the Ministry of Foreign Affairs of the Republic of Korea in cooperation with the Korean Society of International Law and the International Tribunal for the Law of the Sea. I want to congratulate the organizer of the conference for putting together an excellent program that will allow us to discuss and reflect on the theme of regional cooperation and marine environmental protection in these difficult times. On our part, here in the Tribunal, it is always a pleasure and honor to collaborate with our Korean counterparts. By now, I'm sure many of you are quite familiar with this mode of the conference, combining physical and virtual participation. In fact, due to the pandemic and the difficulty to organize in-person meetings, my tribunal also had to adjust its working methods and adopt a hybrid format of meetings, including hearings and deliberations. Of course, it has been a big challenge for us, but I'm pleased to inform you that we have been able to adjust to this new reality quite well. I'm sorry that I'm not able to participate in the conference in person, but I can tell you that my appreciation for this conference is no less than that of you who are present in the conference room. I also want to thank the organizer for allocating this decent time slot for me in the morning. I know that in the remote conference, it is always a challenge to find a convenient time for everyone when participants spread throughout different time zones. Dear colleagues, today I want to take this opportunity to say a few words about the contribution made by my tribunal in the field of marine environmental protection. As you know, International Tribunal for the Law of Sea was established in 1996 in accordance with Annex 6 to the United Nations Convention on the Law of the Sea. The principal task of the tribunal is to settle disputes concerning the interpretation or application of the convention. The tribunal and its seabed dispute chamber also give advisory opinions. Over the past 20 years or so, 29 cases, both contentious and advisory, have been submitted to the tribunal and its chambers. The subject matters of those cases were wide-ranging, but the protection of the marine environment has been one of the most prominent subjects the tribunal had to address. At least 5 cases were entirely or partly concerned with the international environmental law. They include Southern Bluefin Tuna case of 1999, Mox Plant case of 2001, Land Reclamation case of 2003, and responsibilities and obligations of states with respect to activities in the area of 2011. And finally, request for advisory opinion submitted by Sub-Regional Fisheries Commission of 2015. This was not totally unexpected, but nonetheless was a surprising, I must say, pleasantly surprising development. It was not unexpected if you consider the prominence environmental issues have gained in international relations in general in the past decades, and the importance attached to the protection and preservation of the marine environment in the Law of Sea Convention in particular. On the other hand, it was a pleasant surprise if you also consider that before 1990s, few environmental disputes had ever been submitted to interstate adjudication. Bering Sea fur seals arbitration of 1893, Trail Smelter case of 1938 and 1942, and Lac Lanu case of 1959 may be more or less all we can count. Few states that have been victims of environmental damage have considered judicial and adversarial means as a serious option against source states to stop the damage or seek compensation. There may be several reasons for this paucity of international environmental cases. Despite growing concerns about the state of global environment and frequent rhetoric on the importance of its protection, doubts had lingered about the existence of general or customary international law of environment and the utility or relevance of interstate adjudication to resolve environmental disputes. For example, international environmental litigation frequently raises intricate legal issues. Some key principles of international environmental law, such as no harm principle or due diligence principle, are in no way clear. The burden and standard of proof in international environmental dispute are very difficult, if not impossible, to fulfill, not least due to the prevailing uncertainties in scientific and technical knowledge and information. As activities causing environmental damage are in most cases carried out by private actors, the question of imputability, in other words, whether such activities are imputable to states, needs to be examined. It is also a challenge to demonstrate a causal link between states' acts and injuries suffered as a result in such context. Remember, all these legal issues may have to be addressed against the background of today's complicated realities. In fact, many international or transboundary environmental problems may not easily be fit into simplistic framework of source state causing environmental damage to a victim state. The factual situation can be a lot more complicated. Today, international environmental problems are often the result of mutual and cumulative effects of numerous sources of pollution in a number of states. Most states are both sources and victims at the same time, although their contribution to the problem and the extent to which they are affected may vary considerably. However, this prevailing skepticism, if I may say so, toward international environmental law and international environmental litigation has started to dissipate in the 1990s, especially with ICLS, together with the International Court of Justice, taking a lead in clarifying and developing international environmental law, and thus opening a new chapter for international environmental adjudication. As far as marine environmental protection is concerned, I can say that today, international adjudication has emerged as a viable option for any state in its efforts to prevent environmental damage and seek remedies for such damage. Distinguished participants and dear colleagues, now let me address briefly the environmental jurisprudence of my tribunal and its contribution to the development of international environmental law. You may know that the Law of Sea Convention is considered one of the most comprehensive environmental treaties, attaching special importance to the protection and preservation of marine environment. However, the convention, despite some mechanism allowing for flexibility, is essentially a product of the law and realities of 1970s and early 80s. The challenge facing the tribunal is therefore how to make the convention relevant in an area in which law and realities change fast and will continue to do so. I think that the tribunal has responded to this challenge quite well by interpreting and applying various provisions of the convention related to marine environment in accordance with the evolving state of international environmental law. Let me make a few points in this respect. First, the tribunal has taken a rather broad view of the scope of the marine environment, as well as that of the obligation of states to protect marine environment. According to the tribunal, the protection and preservation of the marine environment is not confined to Part 12 of the Convention. In this vein, the tribunal found that the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. The tribunal also noted that Article 192 of the Convention imposes on all states parties an obligation to protect and preserve the marine environment, and this provision applies to all maritime areas. In fact, Article 192, which imposes a positive obligation to protect and preserve marine environment, compared to, say, Article 194, which reflects no harm principle, is a fundamental provision, the potential of which has yet to be explored in the years to come. Second, the tribunal emphasized the duty of cooperation in the protection of the marine environment. In a well-known passage in Mok's plant and land reclamation in and around Straits of Johor, the tribunal stated that, I quote, "The duty to cooperate is a fundamental principle in the prevention of pollution of the marine environment under Part 12 of the Convention and general international law, and that rights arise therefrom which the tribunal may consider appropriate to preserve under Article 290 of the Convention." This finding of the tribunal needs to be appreciated, particularly in the light of the fact that while duty of cooperation is set out in the Convention in certain limited contexts, it was not sufficiently clear that this duty can be applied as general international law. Thus, it is significant that tribunal referred to the duty of cooperation not only under the convention, but under general international law. Thereby, the tribunal recognized the customary legal status of this duty, enabling the tribunal to invoke it as applicable law in interpreting the relevant provisions of the convention. Third, the tribunal has demonstrated a proactive attitude in acknowledging the precautionary approach, perhaps more than any other courts or tribunals. While the precautionary approach had been pleaded in cases before international court and tribunals, the tribunal's ruling in Southern Bluefin Tuna was the first to apply the core element of this approach. Without employing the term precautionary approach, the tribunal in this case prescribed the requested provisional measures using reasoning and an expression which closely resemble the precautionary approach. In the subsequent advisory opinion on responsibilities and obligation of states with respect to activities in the area, the seabed dispute chamber of the tribunal took a few steps further to clarify the legal status of the precautionary approach. The chamber came close to acknowledging the customary legal status of the precautionary approach when it stated that, I quote, the precautionary approach has been incorporated into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration. In the view of the Chamber, this has initiated a trend towards making this approach part of customary international law. Fourth, the tribunal clarified the obligation to conduct environmental impact assessments. In the above advisory opinion, the Chamber noted that the obligation to conduct environmental impact assessment is a direct obligation under Article 206 of the Convention and nodule and sulfide regulations of the authority. The Chamber then went on to state that it is a general obligation under customary international law. Fifth, the tribunal and its seabed dispute chamber elaborated the duty of due diligence, which is central to interstate environmental disputes involving the activities of private entities. As you may know, many maritime activities are conducted by private actors, be they natural or juridical persons. On the other hand, the Law of Sea Convention, and most international treaties as well for this matter, imposes various obligations, including those to protect and preserve the marine environment upon states. Those obligations of states encompass not only direct obligations, but also obligations to insure. The second type of obligations matters with respect to activities carried out by private actors. In this respect, a question may arise as to what are the nature, scope, and content of such obligations. In fact, this was the question my tribunal and its seabed dispute chamber had to examine closely in their two landmark advisory opinions. This question was at the heart of the request for an advisory opinion submitted to the seabed dispute chamber in the context of the obligations of sponsoring states with respect to activities carried out by contractors in the area beyond national jurisdiction. And then to the tribunal in the context of the obligations of the flag state with respect to IUU fishing conducted by its fishing vessels. In response to these questions, the tribunal and its seabed dispute chamber elaborated the obligation of due diligence applicable to states in this regard. According to the chamber, I quote, it is an obligation which entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement and the exercise of administrative control applicable to public and private operators, such as the monitoring of activities undertaken by such operators to safeguard the rights of the other party. The chamber further stated, I quote, the content of due diligence obligations may not easily be described in precise terms. It may change over time as measures considered sufficiently diligent at a certain moment may become not diligent enough in light of new scientific and technological knowledge. It may also change in relation to the risks involved in the activity. The, stand, the standard of due diligence has to be more severe for the riskier activities. By elaborating the obligation of due diligence, the tribunal and its chamber clarify the nature, content, and scope of the obligation of the states with respect to certain maritime activity, such as seabed development or fishing activities conducted by private actors. These findings may also be of general relevance to any activities of private actors that may cause damage to the marine environment. Dear colleagues, the above findings and other relevant rulings of the tribunal and its chamber demonstrate their willingness to be proactive in preserving and protecting the marine environment. In so doing, I think that the tribunal has emerged as an important voice to safeguard the marine environment and promote ocean sustainability for state parties to the convention as well as the international community as a whole. Before closing, let me add a few words about what the tribunal should consider in addressing international environmental disputes. In this regard, I may point out a couple of things. First, tribunal needs to be more proactive in utilizing various means available to it in addressing environmental disputes involving complicated scientific and technical matters. As you may know, perhaps one area in which science and law are most inextricably linked is the protection and preservation of the marine environment. The very definition of pollution of the marine environment in Article 1, paragraph 1.4 of the Convention is essentially a scientific one derived from wording developed by the group of experts on the scientific aspects of marine pollution. In light of such close link between law and science in marine environmental protection, it is no surprise that an environmental dispute would frequently involve the complex issues of science and technology. When complex scientific issues are at the heart of the dispute, or constitute at least a part of it, it poses a huge challenge to international courts or tribunals whose members are not equipped with adequate knowledge or the appropriate background to cope with them. In dealing with disputes involving scientific and technical matters, the tribunal should be braced to go beyond its traditional method of fact-finding and making full use of different possibilities available to it under the Convention, its statute, and rules. For example, Article 289 of the Convention allows the tribunal to select experts to sit with the tribunal in any dispute involving scientific and technical matters. However, Article 289, despite its innovative nature, has never been utilized so far. Of course, what methods and means are most suitable and effective will depend upon the nature of particular dispute and the scope and relevance of scientific issues involved in dispute settlement. Those methods and means are not mutually exclusive either. In particular, the tribunal should not be shy of enlisting the assistance of experts whenever such a need arises. In fact, the best way to avoid the danger of reaching a decision based on facts that the tribunal could not fully comprehend is to resort to the knowledge and expertise of appropriate experts. Another consideration I want to mention is that the tribunal should be more willing to consider and apply significant normative developments in the field of environmental protection subsequent to the adoption of the convention in addressing environmental disputes or issues. I have already mentioned that the Law of Sea Convention is a product of law and realities of 1970s. And challenge facing the tribunal is how to make the convention relevant today in an area in which law and realities are evolving fast. In this regard, I want to remind you that the convention, as a comprehensive framework of legal principles, does not in general attempt to prescribe a detailed set of rules or standards for the various subjects it deals with. Instead, the convention first formulates a general duty and then refers to and incorporates those rules or standards developed in other legal instruments into its ambit. This approach is intended to give specific content to the general duty enunciated by the convention. It also serves a useful purpose of enabling the convention to update the content of the general duty, thus ensuring the long-term relevance and the validity of the convention. This so-called rule of reference is widely employed, particularly in Part 12 of the Convention on the Protection and Preservation of the Marine Environment. One of the consequences of employing the rule of reference is to impose legal obligation on a state to apply certain rules and standards, which it would otherwise not have been legally bound to apply. In such a situation, the rules and standards applied to the states, not because they are legally binding as either treaty or custom, but because they are incorporated into the convention through the rules of reference. Therefore, the rule of reference is a crucial instrument to update the convention, in particular in the field of marine environmental protection. Accordingly, it is important for the tribunal to look into legal developments subsequent to the adoption of the convention and incorporate them in interpreting and applying the relevant provisions of the convention. Through this exercise, I think that the tribunal can make significant contribution, not only to make the convention relevant today, but also to the development of international environmental law. Distinguished participants and dear colleagues, in closing, I can assure you that adjudication can be considered one of the means to address international environmental dispute. I can further assure you that the tribunal is well suited and ready to tackle any such disputes submitted to it, and through this to make contribution to the development of international environmental law and the protection of the marine environment. I also want to take this opportunity to convey my special thanks to the government of the Republic of Korea for its support for and commitment to the work of the tribunal over the years. Thank you very much for your kind attention.
Please give Judge PAIK a big round of applause. Thank you, Judge PAIK, for your insightful and valuable remarks.